Welcome, everyone. Thank you for listening to the Council of Institutional Investors, Voice of Corporate Governance, the number one corporate governance podcast in the U.S. as determined by Million Podcasts. I'm your host, Jeff Mahoney, General Counsel of CII. Our topic for this episode is the recent research paper entitled The New Political Economy of Delaware Corporate Lawmaking. And my special guest today is the co-author of that paper, Edward Rock, the Martin Lipton Professor of Law and Director of the Institute for Corporate Governance and Finance at the NYU Law School. Welcome back to the program, Professor Rock.
Thank you, Jeff. Good to be here.
Professor, your new research paper recommends significant changes to how Delaware corporate law is promulgated. Before we discuss your recommendation, can we begin by first explaining to our listeners why is Delaware corporate law so important to long-term institutional investors?
Well, it is one of the historical oddities of the United States that corporate law is state law, not federal law. Delaware is the leading jurisdiction for corporate law. More than half of the Fortune 500 companies are incorporated in Delaware. And so Delaware is effectively national corporate law. And because corporate law is important for public corporations and private corporations, it's therefore important for institutional investors as well.
Professor, your paper describes the traditional process for making Delaware corporate law and how that approach broke down in connection with the 2024 and 2025 amendments to Delaware General Corporation Law. So can you describe to our listeners the traditional process, some background and overview of the 2024 and 2025 amendments, and then why you believe those amendments resulted in a breakdown in Delaware corporation law?
So Delaware is a very small state, and it became the incorporation capital back in the 19-teens and 1920s when New Jersey forfeited that position. It's an incredibly important area of activity for Delaware. In fact, about 1/3 of the Delaware budget comes from revenues paid by corporations that are incorporated in Delaware. So corporate law is enormously important in Delaware, and there's a state commitment to continuing to update and modify the corporate law as necessary as time goes by. But it's a small state, and the legislature only meets 5 or 6 months out of the year. It's a general state legislature and has very little corporate law expertise. So historically, the task of updating Delaware corporate law has been handed off to an institution called the Corporation Law Council, which is the executive committee of the corporation law section of the Delaware State Bar Association. Historically, it has done a very good job because it has been able to leave client interest at the door and to consider what is the best corporate law for Delaware as their mission. And they've done this since 1967, when the statute was completely overhauled. This process has broken down in recent years under client pressure. And I'd say primarily client pressure from Silicon Valley. It started in the 2024 amendments, where the three opinions that had been decided by the Delaware Chancery Court were reversed by the legislature, even before the Delaware Supreme Court had a chance to review them. Why were they reversed? They were reversed because a bunch of lawyers said, these opinions are wrong, and we need them reversed. The leading opinion there was a case called Moelis, after Moelis and Company, the investment bank. And it involved stockholder governance agreements and whether they were consistent with the Delaware General Corporation Law. Vice Chancellor Laster held that a particularly extreme stockholder governance agreement was inconsistent with core principles of Delaware corporate law. And this set off a reaction because people worried that other stockholder governance agreements that they had written were no longer valid. Rather than going through the traditional process, which was to allow the Corporation Law Council to raise the issue, to deliberate over it, to try to reach a consensus in what is typically an incremental interstitial reform, Instead, the process was sharply accelerated under the pressure of client interests, and the result was not a very good result substantively. Then in 2025, after the Delaware Chancery Court decided the case of Tornetta versus Musk, which held that Musk's compensation, his $56 billion compensation package, had not been properly approved, Musk started tweeting, and Delaware panicked. Meta apparently told the governor that it was considering leaving Delaware. And in response to that, Delaware abandoned its traditional process, abandoned letting the Corporation Law Council take the lead. And the governor appointed an ad hoc committee that within 2 weeks had completely overhauled a key provision of the Delaware General Corporation Law that governed interested transactions involving directors and officers, and now also controllers. This was done, again, without waiting for the Delaware Supreme Court to even review the decision. We now know that the Delaware Supreme Court reversed the remedy in Tornetta against Musk and allowed Mr. Musk to receive his full compensation. But in response to this pressure, they abandoned the normal process, had an accelerated process to completely revamp a very complex section of the code, brought it directly to the legislature, and only then allowed the Corporation Law Council to make comments. And these two sets of amendments have really called into question, in my mind, the ability of the Corporation Law Council to play its historic role of leaving client interests at the door and deciding in a disinterested way what is the best corporate law rule.
Professor, your paper states, quote, Delaware currently faces a tangible short-term threat that companies will choose a different state of incorporation and a more intangible, but in our view, ultimately more severe long-term threat of intrusion, unquote. Professor, let's start with the short-term threat. Your paper references competition from Texas and Nevada as a short-term threat. Which of those two states presents the bigger competitive threat to Delaware, and why?
The pressure that was brought on Delaware was basically through controlling shareholders threatening to reincorporate their companies in either Texas or Nevada. I don't think currently either Texas or Nevada poses a significant threat to Delaware. They each have begun a process of trying to compete with Delaware for incorporations, and they're both revising and reforming their corporate law system to make them more attractive destinations. Texas, as part of its desire to build the business sector, which has been very successful in wooing headquarters to Texas, mainly from California. And Nevada, which historically has competed with Delaware, is trying to, you might say, up its game to be a more credible competition. At present, neither is credible. In Texas, the key problem is that the right to a jury trial is in the Texas state constitution. And those of us who have been around for a while remember the Texaco Pennzoil litigation back in the 1980s, in which a jury awarded a huge judgment against Texaco. So Texas, with the jury trial, is unlikely to succeed, I think, in attracting many companies, but they're working on trying to eliminate that to make it a more attractive jurisdiction. They have created a new corporate law court, which is designed to be able to provide specialist judges. But it's a work in progress. Nevada historically has, since really 2000, has competed with Delaware. Up to now, it has been viewed largely as a jurisdiction for people who don't want any significant oversight. But it's also trying to up its game. It's likewise trying to create a specialist court and trying to improve the quality of its law. One can argue back and forth about the quality of the actual legal rules in both jurisdictions versus Delaware. But the main thing is that in neither jurisdiction do you have the body of precedent or the kind of predictability that you can get with expert adjudication in Delaware. So for most companies, it's not a plausible alternative. I once heard on a panel in Silicon Valley, a artificial intelligence CEO, that is to say, a CEO for an artificial intelligence company, say, in Silicon Valley, we say, innovate in your product, not your governance structure. And I think that's pretty sound advice. Delaware is the standard for a good reason, because Delaware has a rich set of precedents. It has expert judges. It has a state Secretary of State's office that provides efficient service. And for most companies, it's the easy decision where to incorporate.
Professor, a follow-up question to that. I'm going to give you a hypothetical. If I'm a long-term institutional investor and I have the ability to influence where a corporation is incorporated, and I have four choices: Cayman Islands, Delaware, Nevada, and Texas. Can you rank order those four options in terms of most to least shareholder friendly and explain the basis for your ranking?
So clearly, Delaware is number one. Delaware, as I say, has a history. It has expert judges. It has rich precedents. It has very good service. Second, I would put Nevada and Texas. I think different companies have different needs, and both Nevada and Texas will keep you within the U.S. system. And remember that state corporate law is only one source of protection for shareholders. The other major source, of course, of protection for shareholders is federal securities law. And for publicly held corporations, federal securities law may in fact provide the main protection for shareholders. And if you're incorporated in Delaware, in Texas, or Nevada, like in Delaware, you're subject to federal securities. The problem with the Cayman Islands is twofold. One is the law is not as well developed as Delaware. The enforcement is quite different. But most importantly, it's a foreign jurisdiction, and so it doesn't have the same set of protections under the federal securities law. Years ago, we established a system in federal securities law that a foreign private issuer, if it complies with its home jurisdiction requirements, has lighter U.S. requirements. And that, of course, has been taken advantage of by some very good companies that come from jurisdictions with serious domestic corporate law, but also for some sketchy companies that come from jurisdictions without significant home corporate law. And that is one of the criticisms of the Cayman Island incorporated companies, especially the Chinese companies that have entered the U.S. capital markets through Cayman Island vehicles.
Professor, let's now move on to what you describe as a long-term threat of intrusion to Delaware. Can you explain that threat and how serious it is, both to Delaware and long-term institutional investors?
Delaware, as I say, in the United States, we have this curiosity that corporate law is state law, not federal law. And going back 60, 70 years, that's been an issue. The issue has been, why do we let Delaware make corporate law? Why don't we have it made in Washington, where we have a national legislature? And Bill Carey, who taught at Columbia, who was chair of the SEC, put it this way. He said, the first step of having good corporate law is to escape from the present predicament in which a pygmy among the 50 states prescribes, interprets, and indeed denigrates national corporate law policy as an incentive to encourage incorporation within its borders, thereby increasing its revenue. And starting with Bill Carey up to the present, there has been periodically a pressure to nationalize corporate law, either in creating minimum standards or doing so entirely. It happens every time there's a financial crisis. So it happened around 2000 with the dot-com bubble bursting, and it happened again in 2008 after the financial crisis. Going into the last election, Elizabeth Warren and Bernie Sanders each had proposals to nationalize corporate law. Now, the problem I see is I think Delaware, when it follows its own processes, is far and away the best corporate law. Substantively, I think it's the best corporate law. I think it's a superb corporate law, both nationally, it's better than any other state, and internationally, I put it up against any other company, any other country in the world. So what I worry about is that when Delaware allows controlling shareholders to politicize the process, that this is going to increase the likelihood of federal intrusion into corporate law. To put it in the most dramatic way, my nightmare scenario is a coalition between Elizabeth Warren and Elon Musk pushing to nationalize corporate law for each of their different reasons. And that, I think, in a world in which we have so much politicization and such pressure to move to extremes, that could be absolutely terrible for American business and for institutional investors. Because what we have in Delaware is, I think, a really good system that provides substantial protection to shareholders, both of public and private companies. And the idea of corporate law being made not in Delaware, but in Washington fills me with dread.
Professor, your paper argues that one of the causes of the recent significant departure from the traditional process by which Delaware law is made are recent changes in the capital markets. And one of the changes highlighted in your paper is the increase in the number of dual-class companies over the last decade. Can you explain for our listeners what is dual-class capital structures and why you believe the use of that structure has undermined the stability of Delaware corporate law?
So let's start with what a dual-class capital structure is. Corporate law in Delaware and elsewhere allows corporations to choose to have different kinds of stock. You can have one share, one vote, which is pretty standard, or you can have two classes of stock, one high vote stock and one low vote stock, or one voting stock or one non-voting stock. Historically, Ford Motor Company was one of the leading examples of a dual-class capital structure of which the Ford family controlled the high voting stock and through the high voting stock controlled the company. The New York Times has a similar sort of structure. Starting in 2004, when Google went public with a dual-class capital structure that allowed the Google founders, Sergey Brin and Larry Page, to control the company with only a fraction of the equity, we've seen an increase in the number of controlled companies that have dual-class capital structure, which is to say, and this especially accelerated about 2015 to the present. So presently there are, according to your list, Jeff, somewhere around 380 publicly held companies that are dual-class controlled companies. Now, the problem with this structure is that it creates an incentive for the small minority controller, the controller who controls the company through high voting stock, but only holds, say, 10% of the equity. It creates an incentive for that controller to take side payments because they only receive 10% of the increase in the value of the company. Compare that to Bill Gates at Microsoft. Bill Gates, when he was CEO, held 45 or 50% of the Microsoft stock, which is not a dual-class company. He never took more than $675,000 a year in salary and bonus as the CEO. Why? Well, that sent a signal to the workers to the employees at Microsoft that he was in it with them, that if the value of Microsoft went up, he received 50% of it. If it went down, he bore 50% of the cost. It also sent a signal to other senior management that they should not be excessively demanding in their compensation, because if the CEO is only getting paid $675,000, how can they demand really large pay packages? Compared to that, if you have only 10% of the equity, you don't receive the same portion of the gains or bear the same portion of the loss. So you have much greater incentive to seek large compensation packages, for instance. That's the first step. The second step is you also have an incentive to put pressure on Delaware to reduce its scrutiny of those kinds of compensation packages and other conflict of interest transactions. Because you want to get your side payment, and you don't want some judge in Delaware to tell you you can't have it. Finally, it creates what I think is the most dangerous threat, which is the possibility for a controller to threaten to take a company out from Delaware to another state like Nevada or Texas if Delaware doesn't dilute its shareholder protections. And it's that threat, the credibility of that threat, that I think we saw in the last year and a half. It's the threat of the Silicon Valley controllers to leave Delaware which they can effectively do simply by convincing their board of directors, who of course they elected, that it's in the company's interest and in the controller's interest to leave. They can credibly threaten to leave Delaware unless Delaware dilutes its shareholder protections. And that's, I think, what we saw happening. And Delaware proved that it is vulnerable to that pressure, that it will cave to that sort of pressure in the 2025 changes.
Professor, the last section of your paper includes a detailed recommendation for how Delaware can design a new structure and process for amending Delaware corporate law that's more likely to promote long-term interests. So can you walk our listeners through your recommendation, including how and why you believe the Council of Institutional Investors should be part of that solution?
So the existing Corporation Law Council is primarily composed of practicing lawyers in Delaware. It's dominated by the large firms who represent companies. Now, on its face, that seems problematic. Why? Because how could it be legitimate for the lawyers who represent companies to be writing the rules that govern those companies and their relationship with their shareholders? The traditional answer the traditional process has an answer to that. Traditional process says when we go into the council chamber, the room, we leave our client interests at the door and we consider only what is the best corporate law for Delaware. I think the ability of the council to do that, to set client interests aside, to put on their Delaware hat, has been compromised by the pressure brought by the rise of dual class controllers and the ability to channel that pressure into Delaware through the law firms that represent them. To save the Delaware system, it seems to me, we have to reconstitute the primary body responsible for updating the corporate law so that it is able to resist the pressure that is being brought to bear on Delaware by these controlling shareholders. To do that, it seems to me we need to reduce the number of currently actively practicing lawyers who are subject to that pressure, instead relying on, for expertise, on retired lawyers who no longer face that pressure and can prioritize Delaware's interest. In addition, it seems to me it's important to have other voices in the room, including the voices of both companies. So we suggest that the Delaware State Chamber of Commerce appoint representatives, as well as a voice that represents the interest of institutional investors, which is why I think it's important that the Council for Institutional Investors have representation on this new corporation law commission. Because everybody, I think, in the capital markets has a common interest in having corporate law that provides adequate protection for shareholders, while not interfering with the ability of companies, of boards, to take risk and necessary to develop new and revolutionary products. I think that balance has gotten out of whack because of the pressure brought by controllers and the vulnerability of the Corporation Law Council to that pressure. And it seems to me the best way to prevent federal intrusion is to reconstitute the lawmaking process in Delaware so that it's able, in fact, to leave client interests at the door and to adopt the corporate law that is best for all of the folks who depend on Delaware corporate law, the companies and the investors.
Professor, final question. For those listening to this podcast that support your recommendation to improve the structure and process of making Delaware corporate law, what would be the most effective way for those supporters to advocate for the adoption of your recommendation?
So we already have the controllers exerting pressure on Delaware through their lawyers and through their public statements. And it seems to me that institutional investors in general need to push back. And it seems to me there are several ways to push back. One is to come out and support. Another is to do, Jeff, what you did in response to these proposed changes, which is to write a comment giving the Council of Institutional Investors view. I think Delaware is open. Delaware, I think, wants to do the right thing. I think Delaware wants to maintain its tradition of having very high quality corporate law. As I say, I think that has gotten out of whack because of pressure from one particular constituency the controlling shareholders. And as in any process, pushing back through the normal ways in which we influence the development of law makes sense. In 2025, with the amendments to the General Corporation Law in Senate Bill 21, there was lobbying. And it seems to me lobbying on behalf of institutional investors is equally valuable and equally important. I don't think it's appropriate for the investor community to sit on the sidelines as the law is being changed in ways that benefit controllers at the expense of investors.
That concludes our podcast episode. On behalf of the Council of Institutional Investors, I want to thank my special guest, Edward Rock, the Martin Lipton Professor of Law and Director of the Institute for Corporate Governance and Finance at the NYU School of Law. If you have any questions or comments regarding this podcast, please feel free to contact me at Jeff, that's JEFF, at CII.org. Until next time, I'm Jeff Mahoney. Thanks again for listening to The Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.